Wake up, wake up.
It's all happening this morning. We've had the theme for this, the theme for that, and you know, I have to do my little drum roll because it's time to welcome Vera De Pisa, our lawyer, on the line. It's going to be a bit of an extended segment this morning, so make sure you have all your calls and questions. This is the time to catch her. We're not pressed for time this morning, so come on, call. It's been in the, well, it was followed passionately in the United States, the Casey Anthony trial. People were fighting on the outside to secure a place to get in to view this trial. At the end of it, after the verdict was given, there was outrage, there was acceptance. We're going to discuss some aspects of that trial this morning. Yeah, we're far-reaching Morning Barbados, but we're going to look, of course, at criminal law. So let's welcome Vera. Good morning, Vera.
Good morning to you and good morning, Barbados.
Yeah, so you were there cheering the verdict with a little pom-pom. Tell us why, Vera.
Well, as a defense attorney, we're always happy to hear that the jury listens to us. That having been said, we need to make it very clear what probably happened in that trial.
But is it clear, though, what happened in the trial? Because the prosecution had, it was mostly circumstantial. You know, experts were brought in, smell experts or scent experts, and they tried to build a case of where she was supposed to have not been happy with her life and decided to do something about it in the most heinous way. The defense, of course, as is usual, you have to prove it beyond the shadow of a doubt. Let's get it.
Right. Starting from the last point, in criminal law as opposed to civil law, you have to prove beyond reasonable doubt. In other words, you have to be sure that the person is guilty of whatever it is they're charged of. Of course, Ms. Anthony had a slew of charges against her, starting from the top and working its way all the way down to the bottom, and they found her guilty at the bottom end. The difficulty with a purely circumstantial case is that there is no real evidence for a jury to latch onto. And one of the most integral parts of a murder charge is that there must be intent. If your expert cannot prove cause of death, it is going to be very, very hard to reach murder. And I was surprised that they went that far. Perhaps if it were starting a little lower, they may have had a greater chance of a result. Well, manslaughter is always on the table when you're charged with murder, because you can come back a little lower down. But again, it is a purely circumstantial case, and in every criminal case, the judge will tell the jury that if there's any doubt, it has to be resolved to the benefit of the accused person.
Vera, what went on in that jury room? What would they have been coached to think? Because the reason why it's a jury of our peers is that there are John and Jane Q. public who are as emotive as the trial had been in the lead up. What would they have been coached? How would they have been guided to think? The
difference, though, between the jury and the general public is that the jury is called upon to be dispassionate. It is okay. There was sufficient media hype over the last 3 years that I believe the entire world, to some extent, had a vested interest in a particular verdict. She was tried in the media and found wanting. There's no doubt about that. I mean, even last night on CNN, I don't wish to call any names, but they were most ungracious in defeat, if you can call them defeated. You have to remember, though, that the jury is told, put your sentiment aside and deal with what is presented to you in court. And they're not presented, I mean, when you not only don't have a cause of death, you have experts who tell you up front that there's no way they can tell you what the cause of death is. There's a lot made about duct tape, but whether it was put on before or after death is actually very critical. Because if you tape up a dead person, you've actually done them nothing. So we have a situation where the jury was very, very carefully guided by the trial judge, because they had to leave the media and the media hype behind when they went into the room. And the two jurors who have spoken so far have let it be known that it was very, very difficult for them, because they obviously had some preconceived notion. Probably it was not disabused during the trial, but there were no hard facts presented to them, or even circumstantial evidence of a certain quality, because you can be found guilty on circumstantial evidence. It just has to be of such a high standard that there can be no other explanation put to it. Because the defense, as much as it probably was not the best tactic to blame everybody else, but
the father, abuse.
Yes, but the defense is not called upon to prove anything at all. And even when a defense is called upon to prove something, you have to remember that the standard is much, much lower. It is just a balance of probabilities, which is just over 50%, whereas proof beyond reasonable doubt is closer to 99%. It doesn't have to be 100%, but it is not much less than that either. So you have a circumstance where what the prosecution's job is a whole lot weightier than what the defense's job is. They simply have to poke holes in the prosecution case, and this particular case was unique to the extent that, in my opinion, the defense did not try to interfere with the prosecution case too much. They just left it as it was because it was generally weak.
Before we go on, we have a call on the line. Good morning, John.
Yes, good morning. This case is very interesting indeed. Now, it's been proven the young lady did not murder the child, the infant, but what bothers me is who actually did. I am not hearing that. Is this case finished? It has to be tried again? I'd like to find out what's the way forward now, please. Thank you.
Great question, John.
It's a very good question, and I'm glad it's asked, because there is this notion that if you are found not guilty, that it means you did not do it. Those are two completely different questions. Whether or not she did it is still up for grabs. What happened in court is that the jury decided there wasn't enough evidence to prove that she did it. That is different from saying that she didn't do it at all. I didn't get the impression from the jurors coming out, because in America they are unique in that you can interview jurors afterwards. In Barbados, we still have to leave them alone. We're not supposed to interfere with the jury before, during, or after a trial. The two jurors who have spoken have made it very clear that this is not about innocence, this is about evidence, and there just simply was not enough of it for them to come to the conclusion that the prosecution wanted them to come to. I mean, even for manslaughter, what is required, whilst there is no intent, you still have to differentiate between that and an accident. And as far as the jury was concerned, clearly there wasn't even enough for accident, because with an accident and a 2-year-old child, there is always the possibility that you can charge the parent with endangering the welfare of the child. And even that, they went past. And I mean, if there really was one thing that we knew before the trial, is that she's a liar, all right? And that is the only thing that she was found guilty on, telling lies to the investigators. 4 counts of simply not being truthful, and that is all. To address the second part as to what comes next, I can't tell you what will happen next, but what I can use is the analogy of the O.J. Simpson case, where the criminal trial failed, but there was a civil trial which has a much lower standard. It is the same standard that is required of the defense now, which is on the balance of probabilities of just over 50% for her wrongful death. And that would have to move from someone who has suffered as a result of the death of the child, which is very likely to be either Miss Anthony's parents, or, well, we haven't heard yet who the father really is, but the father's family, they would have the opportunity, but that is a civil case.
All right, let's take a pause here, because we have a break coming up, but there's some things that we need to look at. The time it took the jury, whether that was a key thing. We talk about what goes from here, but you know that there's the right of the defense to appeal, but in the U.S. there's the double jeopardy. How does that relate to each other? So we discuss a whole lot more when we come back on Morning Barbados.